DTAAs are intended to make a country an attractive investment destination by providing relief on dual taxation. Such relief is provided by exempting income earned abroad from tax in the resident country or providing credit to the extent taxes have already been paid abroad. With the globalization of economies, signing and review of free trade agreements, increase in the number of cross-border transactions, mergers, acquisitions, tax treaties, transfer pricing, etc., the need for a good international taxation lawyer is on an all-time uphill. Hello, everyone, and welcome to your daily dose of legal knowledge on Hour with LawSikho. I'm Aditya, and joining us today on An Hour with LawSikho is Mr. Harshal Bhuta, a CA who has also received an Advanced Diploma in International Taxation from the Chartered Institute of Taxation, United Kingdom. He was selected as the FIT Scholar 2014 to pursue LL.M program in International Taxation Law at Vienna University of Business and Economics, which he successfully completed with honors. Presently, he is working with PR Bhuta and Company, Chartered Accountants Mumbai. He has over 10 years of work experience, and Mr. Bhuta has been a speaker at various forums, including Institute of Chartered Accountants of India, the Chamber of Tax Consultants, Bombay Chartered Accountants Society, and has published a number of articles. Mr. Bhuta, we are absolutely delighted and very excited to have you on An Hour with LawSikho. Thank you so much for joining us today.
I'm excited too. Thank you.
All right, so before we go ahead and continue this conversation about DTAAs and specific provisions of the DTA agreement, we would like to know a little bit more about you. We would like to know how this journey started and what have you been doing all this while.
Yeah, okay. So now that you tell me, I have been practicing since more than 10 years. It seems like a nostalgic journey till now. So I started off my internship with learning transfer pricing straight away instead of, going through the Income Tax Act and the audit provisions and everything. So I had a head start into this field by learning transfer pricing from one of the pioneers in the field. And then I shifted on to specialize in international tax, and I tried out some cases, used to give some opinions. So that's how the understanding built, and that's when I realized that after I qualified as a CA, that this is the field that I really want to be in. This is the field that I want to specialize in, and it's really interesting. It's really intriguing. It keeps you busy because there are a lot of changes that keep happening across the world in this field in India under the DTAs. So that's how my journey has been right till now.
All right, sir. So you said that there are a lot of amendments that come in, and this is like a very rigorous cycle of taxation laws that you got into, which is also my concern, and which is actually my next question. That given the fact that this field is so dynamic, and even the government is so not static about what they are bringing in with GST laws and other laws, let's say, for example. So given that taxation is actually a fear and a phobia of a lot of law students, what interested you in this field 10 years back, and you've given international taxation over 10 years. What attracted you the most about taxation law in the first place? Hello, sir. Can you hear me? Hello? Hello, sir. Can you hear me? Ladies and gentlemen, we are facing a bit of network congestion here from Harshal sir's end, but he would be back with us any moment. Please wait for the while, and in the meantime, from tomorrow onwards, we have Ramanuj and Abhyuday both talking about different issues of laws, which is going to be really interesting. We would love to see Abhyuday and Ramanuj talk together, and tomorrow Abhyuday will be taking a session with Ramanuj on a specific issue related to law. So don't miss out on that. For now, we are waiting for Harshal sir to join us back on this call, and hopefully have him at the earliest. Let's see how it goes about that. How can we go about that? In the meantime, also it's a very humble request that if you have any doubts or queries regarding international taxation, sir is also extremely experienced in transfer pricing and all the laws related to international taxation. In case if you have any doubts regarding the same, you can possibly post your queries already, and we would be more than happy to take them on the course or in the course of the show. That would be great. So if you could do that possibly It will be perfect, and we would be looking forward to it. All right, Mr. Harshal, you're back, and we are so glad you're back.
I am so
Uh,
sorry. It seems the internet connection is unstable today.
That's absolutely okay. We'll try to manage this. So my question
Right.
was that given the fact that international taxation is a phobia for most of the law students, what
Right.
attracted you the most towards international law, international taxation law back 10 years back, and what made you take this option?
No, so when I started off in 2006 with my career, so that's when transfer pricing as a subject was really picking up. So transfer pricing legislation was brought in India in 2001. So over a period of 3-4 years, it was still maturing. It was a new field, and I think that was the most attractive factor which got me into transfer pricing. Because if you look at the Income Tax Act, it's been there since 1961. So many people practice it. So many people study it in depth, and there are so many practitioners into this field. But there were very few practitioners in the field of international taxation per se and transfer pricing. So I think that was the motivating factor, that yes, you could specialize into it. You could become a name that everyone would know in this field. Yes, that was the factor which attracted me.
All right, sir. So we'll straight away move to now talk about what is the career prospects that international taxation has in general. What scope do you see for aspiring individuals who want to make a career into taxation or international taxation, for that matter? How is the regime changing, and how will it be in the future to come, and how will it be accommodating the individuals who are interested to make a career into international
Yes.
taxation?
So this is a very interesting field. As I mentioned earlier, it is ever evolving. And a lot of impetus has been given by this government on the Make in India initiative, which is there. See, taxation per se is a part and parcel of the investments that take place. It's cross-border investments. So with a lot of FDI coming in, with the economy opening up, with the bright prospects of our economy if you view under the global economy, it's a very good combination that the law students could adopt. A lot of law firms recently have started off with the tax teams, which was unheard of 5 years back. So that's the kind of seriousness that international tax has actually gained in the recent times. And the future is really bright in this, because the government, in fact, not only this government, I am really confident that even successive governments will continue to put impetus to the Make in India initiative, whereby a lot of foreign investments would come into India, and you would be required to advise them correctly in order to avoid the litigation under the tax subject.
All right. So before we move ahead, I have a very interesting question from Tushar Verma. He wants to know that since we didn't study transfer pricing in law college, and most of the law colleges do not have a subject as transfer pricing, how can
Right.
one gain sufficient knowledge about the topic?
So basically, transfer pricing is not a tax topic per se, if you ask me. It's an economics topic. So if you see a lot of CA firms as well as law firms which have a transfer pricing team, there are a lot of economists in there. So even MBAs are recruited for practicing transfer pricing. So it's not so technical that one couldn't understand. It's just that you need the right focus, you need to read the right books, and you need to practice with someone who has a good exposure with good clients, when you can actually get your hands dirty on into the subject. So as I told you, there is no barrier that one could foresee when you want to start practicing transfer pricing.
Okay, got it. So, all right, so we'll move to the next question. That is, what scope do you see for individuals? I'm sorry. How important do you think are DTAAs to international taxation regime altogether? How important, and what kind of role does a DTA play in international taxation laws altogether?
So DTAs actually have a very special importance in increasing the cross-border trade per se, if you ask me. So I will come to it, when I'll explain what are the different parts of a DTA, how it is actually categorized. But just to give you a summary, suppose today if a person really wants to get into Southeast Asia, so as of today we don't have a DTA with Hong Kong, at least a one that is signed. A DTA has already been entered into, but it has not been entered into force or into effect. So therefore, one would look into Singapore as a jurisdiction to conduct the trade in the Southeast Asia because of the various provisions under DTA that enable the effective repatriation of dividends, which enable the effective rendering of services between two countries, which enable the rendering of cross-border trade. So impetus is actually given under the DTA. There are non-discrimination provisions which protect you from discrimination by the source country. So there are a lot of provisions. So it's kind of a bundle of provisions which are there for giving you an impetus for conducting cross-border trade. So that's the kind of importance that a DTA has to a particular trade with another country.
All right. Okay, sir. So the next thing that we're going to talk about in this course of conversation is that if you were to introduce DTAAs to a first-year law student, person who does not know what probably DTA is about, how would you explain that?
Yes. So DTA is nothing but it is an international agreement. Currently, it's a bilateral agreement, and very near in the future, it is going to be a multilateral agreement between a lot of nations, where certain provisions are effective in all the bilateral treaties. So currently, if you ask me, it's a bilateral agreement which is there to avoid double taxation in both the states. So if you have a taxation in the source country, suppose you make an outbound investment and that source country taxes you on that income. So the residence country, that is the country in which you stay, is bound or is ought to give a credit for that. It is as simple as that. So it is an agreement basically to avoid double taxation. So therein certain rights have been given to both the countries for specific types of income, that which country can tax which kind of income, so that a businessman who conducts trade is not burdened by taxation of both countries. So it is as
Okay.
simple as that, that you need to avoid double taxation, and DTA is all about that.
All right. Before we move further, I have a question from Kunal Chandriani who wants to know that does transfer pricing affect cross-border M&A deals? If yes, then what is it, in what manner? What is the manner of them affecting the cross-border M&A deals?
Yes. So transfer pricing is very, very considered as a part and parcel of the cross-border deal. So if you see a lot of M&A agreements also, there is a lot of emphasis that is putting on the pricing aspect which is there. So if there is a share swap, then you need to see whether the share swap is at arm's length. If you need to make a asset acquisition in M&A, foreign asset acquisition, then you need to see how it is priced. So it has to be priced correctly, because both the countries would be interested in getting their share of taxes out of it. So it shouldn't either be undervalued from one country's perspective and overvalued from another country's perspective. So that is why it is important even in cross-border M&A deals, which is
Okay, got it. Okay, sir. So we move to the next question, and we'll talk about the areas which DTAs can govern, or the sectors in which DTAs necessarily function. What are those sectors or areas that DTAs govern in general?
So it's not basically areas per se, but details can be classified into different parts. So the first part deals with the scope of the DTA. So who's eligible to access the DTA? So there, the definition of persons is given. The definition of resident is given. So along with that, next part is the part which concerns different definitions. The definitions of the state of India, the definitions of the taxes which are covered, the definitions of the persons which are covered, the definitions of permanent establishment. So that's the second part. So these two are basically introductory parts. Then there is a part concerning taxation of income and capital. So India per se right now does not have wealth tax, but when it did, there were certain agreements which also dealt with avoiding double taxation of capital. So for a moment, let's keep that separately. Coming to the part of taxation of income. So under taxation of income, there are various articles which are there, starting with business income. So how is business income of a foreigner who is doing business in the source country, how is it taxed? Is the source country allowed to tax that? Is it allowed to tax with unrestricted rights, or there are restricted rights? Then coming to dividends, how are dividends taxed? How is income, interest income taxed? So if a person from the source country is paying interest to another person in another country, so how is that person's interest income taxed in the source country? Does the source country have full rights of taxation, or is it restricted to a certain percentage? Similarly, that applies even to income streams like royalty, income streams like capital gains. Then there are income streams like income for individual professionals, then dependent personal services. So all these articles basically, deal with specific types of income, that which country is allowed to tax how much of that type of income. Then going to the next part, the next part is basically relieving double taxation. So there are different methods which are given for relieving double taxation. So that's a specific part, and those will differ from DTA to DTA. So that's why, each DTA has its own significance. Then the last part is special provisions. So special provisions are basically those concerning the non-discrimination clause. Then right now, there's a lot of emphasis which is put on automatic exchange of information. So suppose the Indian government wants some tax information about Vijay Mallya who's sitting abroad. So it can request the authorities, the tax authorities of UK, so that is HMRC, and get the relevant information from them if Vijay Mallya himself is not furnishing the information. So that's the part which is relating to exchange of information. And the last part is basically the part which deals with articles that specify dates when the DTA is getting into force and when the DTA is going to be terminated. So these are the different parts of a DTA. That's it. That is how you need to read, sequentially.
All right. Thank you so much, sir. That was a beautiful answer. I'm going to move to the next question and talk about the various countries that India has probably entered into DTA with. What are some of the most comprehensive DTAs, and what country have India entered into such comprehensive DTAs with?
Yes. So India has a lot of DTAs, more than 80, with more than 80 countries, it has entered into DTAs. So DTAs are also specifically of different types. One is a comprehensive DTA, one is a limited DTA. So limited DTAs, if you see the SARC agreement, which is there. So there, there are no substantial articles dealing with taxation of income, but those are basically for exchange of information. So that's a very specific DTA. Then there are, tax information exchange agreements. So those are also specifically only for exchange of information. Those don't deal with the classification and the categorization of, which income can be taxed by which country. So one of the most important and the comprehensive DTA that I have come across is the one which has been entered into with USA. So the background is very special, So India US DTA, the negotiation took place for more than 15 years. USA wasn't willing to give some of its taxation rights to India. India wasn't willing to give up some of the taxation rights to USA. So therefore, if you see, there are a lot of special articles which are there in the India US DTA, which you would not find either in the OECD model or in the UN model or in the other Indian DTAs that have been signed. So suppose there is an article like branch profit tax, which is not there in any of the other DTAs which is there. There is there is a very detailed article on limitation of benefit clause which is there, which was one of the foremost which India had signed. So after that, there were replications of those articles in the other DTAs that India had signed.
All right. That means that USA is probably the most interesting DTA and the most comprehensive DTA.
Right,
Got it.
right.
All right, sir. So, as I said in my introduction earlier, that DTAs are intended to make a country an attractive investment destination by providing relief on dual taxation. How does DTA effectuate it in general, and what are the main benefits that both the countries can derive out of DTA?
Right. So let's take a very simple example, that India being a capital starved country, if it requires foreign capital, then logically it should give certain concessions to the other country investors. So therefore it will, for an example, negotiate with the other country's competent authority that, we are willing to give this incentive. So therefore, let's take for an example the article dealing with interest. So if a foreign company wants to establish a subsidiary in India and wants to fund it by way of debt, then the interest income, if you ask me, it is taxable in India at the maximum marginal rate, that is 40%. But India may give a concession under the agreement that, India will restrict its rights only to 15% or 10%. So therefore, that's how India can actually give concessions. So it's either 40% or 10% under the domestic tax law, whichever is applicable. So if 10% is not applicable, then you directly go to the tax law 40%. So therefore, India will then say, no, I will restrict it to only 10% or 15% as per the DTA. So that's how it will actually enhance the inflow of foreign capital into India by way of debt. So similarly, there are special articles dealing with dividend also. So if an Indian company that is a subsidiary wants to declare dividends to the holding company, so there also the certain the article restricts the right of taxation to India to a certain percentage.
All right. So you just quoted an example of USA. You just gave a live working example.
Right.
If you were to give me one specific example of a already working DTAA model that
Right.
is already existing with India and some other country, what would it be?
Yeah. So I can give you a very practical example. So I recently worked last week on an assignment where, a foreign Ivy League wanted to conduct courses in India through a marketing partner, and it wanted to naturally know what would be the tax effects of it, what would be the tedious aspect of it. So if you ask me, under the Income Tax Act, there is a specific section, section 917, which deals with income from fees from technical services. So it's a technical training which the Ivy League will give. So technical training also includes managerial or consultancy services. So under the Income Tax Act, the income from the services that the Ivy League will earn would attract a taxation of 10%. However, if you refer to the India-US DTA, there is a clause which states that even if the income is to be categorized as a technical service, there is an exemption which has been given for income earned by educational institutions from teaching activities. So therefore, even if that income is taxable under the Income Tax Act 1961, if one resorts to the provisions of Article 13 of India US DTA, that income would not be taxable at all. So that is how the DTA effectively gives the rights of taxation of that income to USA. Then USA, maybe it would tax that income, maybe it would not tax that income. That is a prerogative of USA. But at least India has relinquished its right to tax the income from educational services.
All right. That was a very apt example. Thank you so much for that. Now, what are the various principles? Because I'm sure that in all these examples, there are certain principles that each country has in mind while they try to negotiate the agreement. So, what is the various principle that a country should keep in mind while negotiating their tax treaty?
So typically how countries negotiate their tax rate, it depends on, what is their taxation base at home. So typically countries could be classified into residence-based countries and source-based countries. So source-based countries are those which are typically starved of the capital, or maybe, they have a lot of resources at hand, but they do not have sufficient capital to capitalize on those resources. So therefore, they will try to extract the maximum of the taxation rights, uh, uh, the shared taxation rights with other countries when they are actually entering into DTA. Just to give you a very simple example, so this is one of a very important logic that a reasoning and a logic that I had learned in my LL.M studies. Take for the example the country of Australia. So Australia is per se a OECD country; it's an advanced country. It has a lot of technology, but at the same time, it has a lot of natural resources. So therefore, persons who really want to undertake mining in Australia, obviously Australia would want to tax the mining income. It would not want to relinquish a large portion of its share taxing rights to the other country. So therefore, it would follow the source model of taxing. It would not follow the residence model of taxing. So residence countries are typically the countries who provide the source of capital into the source countries. So depending on where you stand in your domestic tax base, what does your domestic tax base consist of? Depending on that, countries actually enter into negotiations with other countries, keeping that in mind, that what is the taxation right that I can actually forego, and what is the taxation right that is so important to me that I need to retain under the tax treaty that I am negotiating with other tax countries.
Okay, got it. Thank you so much, sir. Let's try to talk about the next set of questions that we have lined up for you. And this is basically an overview of the articles of DTAA, and we want to know each one of them in detail, given that you have such a beautiful experience. So, you spoke a lot about the residentship of an individual or a citizen, and a lot of things depend on that. What
Right.
is the residential clause, or sorry, what is the resident clause in a DTA exactly?
Right. So to access a DTA, there are two conditions which need to be satisfied. An entity needs to be classified as a person under the definition, and second, the person needs to be a resident. So residence is basically given under Article 4, typically under Article 4 of all the DTAs. So residence typically points back to the residential conditions under the domestic tax law. So if you are a resident under a domestic tax law, then you are allowed and entitled to claim the benefits of a particular DTA. So that is the general trend which is there in all the DTAs as well as the OECD UN model. But there are certain divergences which you would notice in certain DTAs. So therefore, if you ask me if you want me to point out one of such divergence, I can give an example of India UAE DTA which is there. So under India UAE DTA, UAE resident under a person to be qualified as a UAE resident needs to satisfy the residence test of 182 days in UAE. So this number of days test is typically never given under Article 4 of the DTA. It typically throws you back to your domestic tax law. So for example, if a person from India wants to access a DTA, then he needs to be a resident, or if it's a company, the company needs to be a resident under Section 6 of the Income Tax Act. Only if it qualifies as a resident under Section 6 of the Act can it access any of the Indian DTAs which are there.
All right. So then before moving to the next clause that we'll be talking
Right.
about, I have a question from Komal Shah. And her question is that there were recent changes with regard to how commissionaire agreements were dealt with in DTAA. Please
Right.
explain how these agreements are dealt with.
Right. So I think I will cover that under the clause dealing with permanent establishment and business profits. So subsequently, I would cover that in detail.
All right. Thank you so much. Let's talk about the remaining clauses. The next clause that I want to know about is taxes covered. What is that clause and how does it operate? Hello, sir. Can you hear me?
Yes, yes, sure.
Okay. So the next clause that we want to talk about is taxes covered. How does that
Right.
work? How does this article work, and how does it operate?
Right. So this is a very, very important part of the DTA that one needs to read. So in different treaties, different kinds of taxes are covered. Typically, if you see from the Indian perspective, it is typically only the income tax and the surcharge that is covered. And obviously the education says, but if you see from other countries' perspective, so let me give an example. So I had recently read and examined the India-Finland DTA. So under India-Finland DTA, apart from income taxes, even church tax is covered. So if you see the India Japan DTA, so under India Japan DTA, so apart from the corporate tax, even I think one of the local taxes were also covered. So therefore, you need to see, which kind of taxes are covered under the agreement. Why I am telling you that? Because you need to see under the double taxation relief, that against which taxes are you going to get the foreign tax relief. So suppose I, as a resident, have paid tax in Finland as well as in India. But in Finland, I am liable to pay the church tax also. So therefore, I would get the credit of that church tax against the income tax paid in India, and vice versa. A resident of Finland, if he is paying taxes in India, he can get the credit against the local church tax which is there. So therefore, it makes very much sense and importance that you need to see which are the kind of taxes which are covered under a particular DTA.
So, in the same regime, my question to you is that there are certain taxes which are levied in substitution of the existing taxes. Are these
Right.
kind of taxes also covered under DTAA?
Yeah. So typically, under the DTAs, there is a saving clause which is there. You know that after you enter into DTA, if a country typically replaces those taxes with similar taxes in the future, then those taxes would also get covered under DTA. So there was a big UN cry, when equalization levy was introduced by Finance Act 2016. So therein, a lot of people had actually examined whether that is a tax which is similar to income tax and therefore would be covered under the DTA or not, irrespective of whether that tax was introduced by Finance Act or incorporated by way of amendment into the Income Tax Act.
So, all right, so the next thing that I want to know about it is that one of the provisions of this article says that the taxes which are similar in nature are also covered. So that necessarily means, sir, are you there? Can you hear me?
Yes, yes, I can hear you.
Yes. So one of the provisions says that the taxes which are substantially similar are also covered under the DTA, which
Right.
necessarily means that if there's a colloquial language difference or if there is a certain tax which is levied in some other name, they are also covered under the DTA. The question is that in certain countries where certain taxes exist and in other countries where those taxes do not exist or are substantially low, wouldn't that be problematic in the future when they are governed under such DTAs?
So typically, at the time of entering into DTA, it is very clear that what kind of taxes are covered because they would be listed there. So nothing is left open for scope in the future. So that clause basically only helps in case, in the future after signing of a DTA, there is a kind of tax which is introduced, which is, similar to the one which is already levied. So as I give the example of equalization levy. So in fact, I had also examined, whether equalization levy is similar to income tax or not, and therefore it would be covered under that saving clause or not. So that's the kind of effect that that clause has.
All right. So let's talk about this the Article 3, which is the generic definitions or the important definitions. What are some of the most important generic definitions that are covered under a DTA? If you could just tell us just a brief of few of those definitions.
Hello?
Hello, sir. Can you hear me?
Yes, yes, absolutely.
Yes, so let's talk about the definition clause a little and let's try to understand what are some of the most generic and important definitions that are covered in almost every BPA.
Yeah. Okay. So there are certain typical definitions which are covered under DTA. So the important generic definitions, one of the most important is international traffic, which is there, which is very, very important in case of shipping industry. So let's start with that off. So under international traffic, the departure and the arrival point has to be in different countries. So if the departure and arrival point is in the same country, then it cannot get covered. The income earned from international traffic cannot come under Article 8, which is shipping, and therefore the source country can also have the rights to tax that. So that is one of the important ones which is there. Then there is a definition of typically uh, what is the area which is covered under a particular country. So if you see the definition of India in typically all the DTAs, it covers the airspace above India. It covers certain area within the nautical miles from the land boundary of India. And I think a lot of countries also mention, which territories they want to cover under the agreement. So therefore, if you see, I think India, Malaysia DTA, the recent amendment which was there, so that DTA typically wants to exclude the territory of Labuan which is there, so which is typically a tax haven. So therefore, the income which is earned from that territory, that will not be allowed to claim benefits from India, Malaysia DTA. So that
So
is
I would
also.
also
Yes.
I would also like to interrupt you here, and I would like to ask a specific question. I was going through a couple of DTAs. For
Yes.
example, India and China DTA does not cover Hong Kong, and India
Right.
US DTA does not cover Puerto Rico, Virgin Islands,
Right. Right.
Guam, etc. How does this
Right.
work in a definition of a country in itself? How can certain parts of the country be left out from that DTA?
Yes. See, typically it is a sovereign agreement between two governments, right? So those two governments have the leeway to specify, which territories they want to cover and which territories they don't want to cover. So therefore, typically, you can't then allege that, since I am from this territory, I should be covered under this. So the non-discrimination article would not apply in that case.
Okay. Yes, sir. Please continue with the rest of the definitions that we were discussing.
Right. So this was typically, the definition of the state. So what is covered under that? So to, in fact, give you a very good example, in the case of the India-Australia DTA. So Australia actually covers, a lot of islands along with the main part of Australia. So typically Christmas Island, which is there, Ashmore and Cartier Island, which is there, the Coral Sea Island, which is there. So that's a very specific and a very beautiful example of, how much leeway has been given to both countries when they are negotiating a DTA. Then, what is meant by, the income? Hello?
Yes, sir. We can
Hello?
hear you. We can hear you. Please go
Okay.
ahead.
Okay. Yeah. So next, if you ask me, typically a national has been defined. So the word national is very important from the perspective of applying the non-discrimination article which is there. So who is a national? So, in general parlance, we would understand that national typically includes only an individual. But no, under certain DTAs, national also includes a legal entity which is there. Legal entity registered or incorporated in a particular country. So that is an interesting definition which is there. Then the competent authority definition has been given. So therefore, if two countries want to actually, after entering into a DTA, they want to renegotiate some parts of the DTA. So which is the right authority that they need to consult in order to initiate the negotiation part. So competent authority has been defined. So that is there. Then what is included under the definition of person? That's also very important. So typically, person includes an individual, it includes a company, and along with that, it includes a body corporate. So therefore, if you ask me, LLPs would come under the term body corporate because those LLPs and firms typically. So those are not considered separately and not defined separately also. So I think these are the typical definitions that you would find across all the agreements which are there.
So there is also two definitions that I want to talk to you especially
Okay.
about. The first one is what is the definition of dual residency mean, and what does pass-through entities mean in a DTA definition?
Okay. Yeah, so I will cover that. So if you refer to the amendment which was there, which was made to the India UK DTA, I guess that was made in the year 2012 or 13 or something. So therein, even pass-through entities were covered under the definition of person. So what happens is, in India, partnership is considered for income tax purposes to be a body which is separate from the partners. Although for general law purposes, a partner and partnership are synonymous, but for income tax purposes, partnership firm is taxed separately, partner is taxed separately. Although uh, uh, the income which a partner earns from a partnership firm, that is partnership share, is exempt, but that's irrelevant here. So therefore, from Indian perspective, partnership firm and partner are separate. But from a foreign law perspective, foreign taxation law perspective, that may not be the case. So take for the example of UK. So there, a partnership is a disregarded entity. So a partner and a partnership are one and the same. So therefore, if a partner enters into any transaction with India, or a partnership enters into any transaction with India, just because it is a disregarded entity, that itself should not disentitle either of them to the benefits of the DTA. So therefore, as I told you, under the definition of person, so earlier, person included only an individual and a company and an entity which is treated as a taxable unit under the India UK DTA. So if a partnership is not a taxable unit by itself, since it is disregarded, since it is passed through, then it would not have been able to avail the benefits of the DTA. So therefore, the DTA was amended, and now what it says is that even a disregarded entity is allowed to take the benefit of the India UK DTA.
All right. So the next clause that we're going to discuss is about the most important clause, that is the residence. What is the residence clause comprises?
Yeah. So basically, as I told you, the first part of residence clause typically throws you back to the domestic tax law. So it says that a resident of a contracting state typically means any person who is liable to tax under the laws of that your own country. Basically, if you're a resident of a particular country, so what do the taxation laws of that country state? Are you a resident or not? If you are a resident therein by reason of either domicile, which is not the case in India. So domicile is treated. So domicile as a condition is there under the UK income tax laws for considering residentship. Then it could either be by way of place of effective management or by way of incorporation. So under Section 6 of Income Tax Act, for a company, you are an Indian resident if you are incorporated in India, or if you are a foreign company and you have a place of effective management in India, then also you are considered as a resident. So only if you are a resident under the domestic taxation laws can you basically avail the benefit of the DTA, and you qualify as a resident for the purpose of the DTA. Now, what could happen here is that you could become a resident of both countries. So take for the example, a very simple example of India US. So US taxation is based on citizenship, whereas India taxation is based on number of days test which is there. So there could be a situation wherein you are a resident of India as well as the resident of US. So then if you are a dual resident, then how do you read the treaty? Which you are a resident of which country, and which country will get a right to tax which income? So therefore there is a tiebreaker test in case of dual residency which has been given. So for US, it is very specific. There's a savings clause which has been given. So that's if you go to different DTAs, which are other DTAs which are there. So typically, the tiebreaker test runs you through different criteria which are there. So the first one being permanent home. Where do you have your permanent home? So if you are a dual resident of both countries, the tie will be broken in the favor of the country where you have a permanent home. Now, suppose you have a permanent home in both countries. Then what's the next step? The next step is where is a center of vital interest. So where do you have your personal and professional interests in the countries? Then if not that, then where is your habitual abode? So by habitual abode, you mean that for most part of the year, where do you stay? And even if that fails, at the end, discretion has been given to the competent authorities to decide and break the tie in favor of either of the countries. And there could also be a situation that if you are not able to break the tie, then you would suffer taxation in both the countries. So that is the unfortunate consequence of this.
All right. So the next thing that I want to talk about, and very quickly, so because we have 15 minutes left and we have a lot of
Wow.
clauses to discuss.
I
So,
know. Yes.
so let's talk about both the business profit clause as well as the
Right.
associated enterprise clause together. And let's
Okay.
try to understand. I'm sorry. Let's try to talk about the business profits clause and permanent establishment clause,
Right.
and
Sounds
also
good.
in the light of the same, discuss about Komal's question, which was there were differences and changes with regards
Commissioner
to.
agreements. Yeah,
Yes. Yes.
that's on my mind. Okay.
All right.
So typically the business profit clause states that a person coming from a foreign country can be taxed in the source country only if he has a permanent establishment in the source country. So that's why the definition of permanent establishment is linked to the article of business profits. So permanent establishment, there could be different types of permanent establishment. One is fixed place P, which is there. Then is service P, which is there. Then uh, then construction P is there. So there are different types of permanent establishments which are there, and if you satisfy certain criteria which are being given under the definition, and you constitute a permanent establishment, then the source country where you are doing business has the right to tax your income. If you do not have a permanent establishment in the source country, then the source country cannot tax your income there. So that is as far as the business profits article is concerned. So I think let me here introduce you to the concept of general articles versus special articles. So if you see the articles dealing with dividend, interest, capital gains, royalty, FTS, those are specific articles. So specific articles prevail over general articles. So if you're earning incomes which are classified under the specific articles, then you go to the specific articles. If you do not earn such incomes, then you come back to the business profit article, and then you see whether you have a permanent establishment or not. Now, under permanent establishment, there is also a concept of agency fee, which is there, wherein this change in commissioner agreements is very significant. So the change in commission agreement is basically introduced by way of BEPS Action Plan 7, Base Erosion and Profit Shifting. So what that Action Plan 7 states, that if you are a commissioner agent, so typically under Indian common law it is very uncommon to see such kind of agreements. Under civil law jurisdictions you see those kind of agreements which are there. So under Indian Contract Act, an agent typically represents the principal. He does not bill in his own name. He has to bill compulsorily in the name of the principal. He acts on behalf of the principal. So what is different in case of commissioner agency agreements? So under commissioner agency agreements, the commissioner agent typically bills in his own name, although he's representing the principal. So it's kind of an undisclosed principal kind of a situation. So that is how he typically evades the agency agreement, agency permanent establishment conditions. Since he would claim that he is billing in his own name, he is not representing the principal. So that's why this change has been brought in under the permanent establishment article 7, article 5, read with the BEPS section plan 7, where it is stated that, even if you are a commissioner agent, then also you could get classified as an agent P if you satisfy the typical conditions which are there.
All right. So before we move ahead, we also have another question from Komal that I would like to take at this point of time. I hope, Komal, your previous question was answered. Many countries nominate and send country leads to set up and develop specific departments in India. Are there any provisions of DTAA which govern this?
Sorry, I didn't catch that question.
So the question says that many countries nominate and send their country heads to set up and develop specific departments in India. Any provisions
Okay.
of
Yeah.
DTAA which
Yes.
governs
Yes.
this?
Yeah. So typically, if you see under FEMA, there are provisions wherein a foreign company is allowed to set up either liaison office or branch office or project office in India. So if you set up a liaison office in India under FEMA provisions, you are not allowed to conduct business. You are not allowed to do sales. So typically, liaison office is associated with marketing and promotion activities. So when you want to test the waters of a foreign country, You send your personnel to see, what is the how is the market there. Can I adapt to the market? Do some market research, do some advertising, gauge the response of the market. So if you set up a liaison office, you are not doing business in those countries. You would not constitute a fixed place fee. So therefore, that is one of the most and the foremost advantages that DTA offers to such kinds of establishments which are there. But the moment you transform that, the liaison office, into a branch office or a project office, you constitute a P in India, all the respective countries wherever you set up that kind of office, and the profits which are attributable to that permanent establishment get taxed under Article 7, which deals with business profits.
All right. So let's quickly move to the next set of questions and the next set of articles that we're about to take an overview of. The next article that we're going to talk about is associated enterprise. What does that comprise of?
So this typically relates to the transfer pricing exercise which needs to be done. So this is the only article which actually deals with economic double taxation under DTA. Otherwise, all the other articles deal with juridical double taxation. So by juridical double taxation, you mean that one person is getting taxed in two countries, whereas under Article 9, it is two entities which are getting taxed. And if one entity gets taxed not in accordance with the arm's length principle, then the other entity can actually go to its competent authority and tell the competent authority to negotiate with the other country's competent authority to get into an agreement whereby both would be taxed in parity. Otherwise, what could happen is, if the taxation authority of one country makes an addition to the income of the subsidiary, say a subsidiary, the other country typically would not give the benefit of that, because there is no double taxation here. It's two entities getting taxed in different countries on their respective incomes. But there is economic double taxation because there is an addition made here. The same type of income is taxed in two countries. So that's where the article of associate enterprise comes into play to relieve economic double taxation.
Right. So the next set of articles that I'm going to discuss right now are all the ones which are the economic gains that one gets out of the DTA, dividends, interest, royalties, and capital gains. How are these articles placed, and what are the inferences that one can draw in a DTA agreement?
Yeah. So typically, if you see the structure of the articles dealing with dividend, royalty, and interest is typically the same. So there, the source country is given a limited right to tax that kind of income, and the residence country anyway can tax under the domestic tax law in the manner that it stipulates. So those are the two important uh, uh, sub articles under these articles that need to be taken care of. One is that which country can tax what kind of income, and second is to what extent is the source country's taxation rights limited to. Then obviously these kinds of income streams are defined. So what is meant by dividend under the DTA article? What is meant by interest under the DTA article? What is meant by royalty? So you even need to see, whether that royalty definition is at par with the definition under Income Tax Act or not. If it is not at par, and if the royalty definition is restrictive than the definition under Income Tax Act, then that's when the DTA actually comes to your benefit and reduces the taxation in the source country.
So this also brings me to a very important question, this very example, that in case there is a point of non-convergence between the two, between the existing laws and the DTAA, or if there is a point of clash between the two, what
Right.
prevails over which?
So DTA typically prevails over the Income Tax Act, and that has been settled in the Supreme Court decision in the case of Azadi Bachao. But lately, if you see, there has been a section inserted into the Income Tax Act dealing with general anti-avoidance regulations. So it has been specifically mentioned there that the GAR provision would prevail over DTA. Nobody has tested that till now under the courts, that, is it a kind of treaty override? Can you really do that? But that is one of the kind article, where the domestic tax provision prevails over the DTA. But otherwise, in general, if you ask me, all the articles of DTA prevail over the comparative uh, sections under the Income Tax Act.
All right. So the next question that we have for you is, what do you think about the independent personal services under the DTAA, and how does that work?
Yeah. So typically, this article is prevalent in all the Indian DTAs, although that article was removed way back from the OECD model, because under the OECD model, they believe that, the income which an individual earns versus the income which a company earns, there is no difference. But India believes that yes, uh, the article dealing with independent services is a very specific one, because therein, you can actually specify the number of days condition also which is there. So therefore, if an independent professional is earning income in another country, then that income would get would be covered within the scope of the article dealing with independent services, and not the article dealing with business profits. So also the concept of fixed base is equivalent to the concept of permanent establishment which is there. So permanent establishment concept is embedded under, the concept of business profits, whereas here under the article dealing with independent personal services, the concept of fixed base is to be seen.
All right. So the next two important articles that we're going to discuss right now and in the next 4 minutes are double tax relief and non-discrimination clause under the DTAA.
Right.
If you could very quickly wrap the two up and tell us in brief about how do they function. Tell me.
Right. Right. So the one of the most important articles of the DTA is double taxation relief. So now that we have, seen which country gets to tax what kind of income, then coming to the relief that the residence country has to give for the source taxes, you need to resort to reading the article of double taxation relief in detail. So there are different methods which are given. So the different methods are the credit method, the exemption method, and a mix of both. Then there could be variations like underlying tax period which is there, tax pairing which is there. So let me quickly deal with that. So under the exemption method, the residence country would exempt the particular income which the resident would have earned in the source country. So if it is exempted from the tax base, there is no question of taxation on it. Under the credit method, the residence country would tax that income under its own domestic tax law, but it would give a credit for the foreign taxes paid. So there also, there are two sub methods which are there: full credit method, ordinary credit method. So under ordinary credit method, what typically happens, and that's prevalent, that's very commonly found. So the taxation credit, the foreign tax credit which you get, will be limited to the taxation which can happen in your own state. It can't exceed that. So therefore, you can't avail a refund out of the foreign tax credit that you have paid. Then coming to underlying tax credit. So that's a variation of the concept of the credit method. So if you see the India Singapore DTA, for example, so there, that's also kind of relief of economic double taxation. So there, if your subsidiary is distributing dividends to the parent, so you would get a credit for the dividend withholding tax. You would also get a credit for the underlying corporate tax that would have been paid in Singapore. So that's a very typical example which is there. The last concept is tax pairing. So under tax pairing, it's typically given by developing nations, that if you have certain exemption sections in your domestic tax code, then when you are giving credit, the residence country will give a credit assuming that tax has been paid even on the income which is exempt under the foreign country's tax system. So these are briefly the methods which deal with relieving double taxation. Going to the article of non-discrimination clause. So this is a very, very special article which is found in the treaties. So there are different parts to it. So non-discrimination could happen to either a national, it could either happen to a permanent establishment of a foreign enterprise, or it could take place in case of deductions, in the case of payments which a resident makes to a non-resident. And typically the last scenario is the discrimination happens to wholly owned subsidiaries of foreign corporations. So this article is broken up into these different parts, and each part has a specific provision wherein you need to satisfy certain conditions. Only then you can avail the benefit of non-discrimination. So what happens is, if you are discriminated by the source country and you satisfy the conditions for availing the non-discrimination, then the resident can actually stop the source country from discriminating the non-resident vis-a-vis the residents of those countries. So that is how that article operates.
All right, sir, it's 9 o'clock and we come to an end of this show.
Oh,
Thank you so much for being a part of it. It was an absolute pleasure and a delight to have you on this show. And moreover, it was so informative. The whole session was so informative that I was hoping that if I could like stop for a while and take down notes and do my work. So thank you so much for such an informative session. I hope you had a good time.
it was indeed my pleasure. Thank you so much. Thank you for the viewers also for listening patiently. Thank you so
Thank
much.
you so much, sir, for being a part of this. For everybody who's watching us right now, join us tomorrow as Abhyuday Agarwal will be talking about a specific part of law that you probably don't know about. For now, this is me, Aditya, signing off from An Hour With LawSikho. It was an absolute pleasure to be on this show. Do catch us every day from 8 to 9, Monday to Friday. We are going live every day. Thank you so much. Don't forget to like, share, and subscribe. Hit the bell icon as we're going live every day from 8 to 9, like I said. Until then, good night. Take care and out, LawSikho. Thank you so much,
Good
sir.
night. Bye, guys.